Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to another episode of Legal Ease, the show that converts legal jargon into legal ease. And tonight my very special guest is Professor Mohammad Raja. Professor Raja has qualifications. He has a BA Honours with a Master's from PB University. He has a DPLR, which is in Labour Relations in UNISA. He sits on various employment panels. He does arbitration, mediation, facilitation, disciplinary inquiries, and training. Part of his initiative is relationship building, and he has a commercial profile as well. He's an associate professor at UNISA Graduate School of Business Leadership in Johannesburg, where he has lectured since 1980. His expertise is dispute resolution, labor law, negotiation, conflict management, and industrial relations. He is now part-time at the UNISA Business School, and he runs regular workshops on negotiations, conflict, handling discipline and dismissals, dispute resolution, and labor legislation. He has extensive experience as a bargaining forum chairperson. Mohammad is a highly skilled facilitator, mediator, arbitrator, trainer, and relationship building initiative facilitator. Mohammad is also at the Center for Effective Dispute Resolution and an accredited commercial mediator, and he has more than 30 years experience in dispute resolution and relationship building. He attended training at the Advisory Conciliation Arbitration Services in Britain. He is a part-time senior commissioner. He has trained commissioners way back in 1975 for the Commission for Conciliation, Mediation, Arbitration, CCMA. And he was a consultant trainer for the International Labour Organization, ILO, and the Swiss project to train the Department of Labour's staff. He has served as a judge at the ICC International Mediation Competition in Paris, France. Mohammad has served as the editor of the South African Journal of Labour Relations and has contributed to various books and publications, several journal articles and research reports, and has edited several seminars and books. Before joining UNISA, he was an employment consultant and an instructor at the Iranian Air Force Academy. Mohammad Raja is based in Johannesburg. Professor Raja, assalamu alaikum and welcome.
Wa alaikum salam wa rahmatullahi wa barakatuh. And viewers, assalamu alaikum wa rahmatullahi wa barakatuh.
Now, tonight we're trying to understand what alternative dispute resolution means. What is alternative dispute resolution?
Well, firstly, that's dispute. There can be any types of dispute between various options, and there's a tendency to see whether there's a dispute. The first option often people choose is in fact going to court.
Right.
And therefore, alternative dispute resolution means staying out of court, the alternative being mediation and arbitration. So instead of going to court, the alternatives are mediation and arbitration, therefore ADR.
Right. So what we're really saying is that there always will be disputes, and there'll always be various mechanisms to resolve them. Litigation is just one but mechanism.
Litigation is one of the options, and of course ADR is, we believe, for a start, the better option.
Right.
Mediation particularly, because with mediation, parties arrive at what is we normally call a win-win situation, because the outcome is what the parties themselves choose. Whereas if you go to court and you go to litigation, one party wins and one party loses usually.
And most people are familiar with the basis of mediation through the CCMA, where labor disputes are mediated, then arbitrated.
That's correct.
So, the public exposure to mediation is more in the field of, say, labor disputes. But that's now the mechanism of dispute resolution, especially mediation, is now growing to much wider fields, right?
Yeah, in fact, the labor dispute resolution, mediation in labor disputes started in the early 1980s with IMSA, whereas the Arbitration Act in South Africa we had before that. Mediation has been used in South Africa and in Africa generally long before labor disputes and long before the CCMA started mediating and conciliating, or in fact arbitrating disputes. It's been traditional in African countries. It's been, and in Islam as well, amongst the Muslims, mediation has always been the first option to settle disputes. In Africa, because of the community, and rather than individualistic, and it was when Africa was colonized.
Yes.
Then they started putting emphasis on going to court rather than mediating and arbitration.
So what you're saying is historically there's a basis for mediation. I think the most well-known act of mediation was the Prophet ﷺ placing the black stone in the middle of a sheet and inviting the leaders of Mecca to participate jointly in the lifting of the stone. I mean, that avoided a huge amount of conflict. So on a practical term, what you're saying, historically it's been there. We just haven't put a label to this thing called mediation.
I mean, you couldn't have chosen a better example, obviously. And that's what mediation is. It's a third party who is skilled, and obviously Rasulullah Sallallahu Alaihi Wasallam was the most skilled. But it is third party dispute resolution where the third party attempts to help disputing parties resolve their dispute. At the CCMA, for example, in labor disputes, the person is called a commissioner. So the commissioner at the CCMA will assist parties to reach dispute. The commissioner or the mediator doesn't have ruling powers. It is up to the parties whether they want to settle or not. And you can mediate family disputes, you can mediate commercial disputes, all disputes can be mediated. We can bring it down to three friends going out. Two of the friends suddenly argue, and one of the friends then say, well, let's see if we can't solve it. That person then is the mediator.
The mediator. So it appears that there's different rules when one deals with mediation, arbitration, and litigation. So clearly, there are advantages and disadvantages in each of these systems.
Yep.
Let's just take it one at a time. What would be the differences between the three ways of dispute resolution, the advantages and disadvantages in each?
Well, mediation, for example, look, if it's at the CCMA, then the parties don't have a choice. The commissioner is appointed. But if it's private dispute resolution and parties, which is voluntary, parties choose who the person is who would mediate for them. They choose the time when the mediation would take place. They choose, the date, the time, and the venue. And they can even give the mediator a broad outline and say, we only want the following mediated and nothing more. The big advantage of mediation is it's without prejudice, it's off the record, and of course it's highly, highly confidential. One of the key elements of mediation that makes it successful is the confidentiality rule. And it's a process whereby the mediator would talk to the parties jointly, would separate the parties, and the important thing is it's without prejudice, off the record. Arbitration, on the other hand,
it's also inexpensive.
It's inexpensive.
It's less time consuming.
It's less time consuming.
But it's not binding.
It's not binding till the parties reach an agreement and they sign an agreement, because then it's a contract.
Right.
Till that stage, it's off the record. An important thing about the off the record part of mediation, anything that happens during the mediation, perhaps the parties make moves during the mediation, there's offers, there's counter offers. If there's no settlement at the end of the mediation, the parties can go back to the positions that they were at before they came to the mediation.
And you can leave the mediation process at any stage.
You can leave because it's voluntary.
Voluntary, yes. Right? Okay.
So that would be mediation broadly.
Right.
Arbitration at the CCMA, of course, is governed by the Labor Relations Act, but you can have arbitration outside of labor disputes. Any dispute can be arbitrated Because in South Africa, we've got, for example, the Arbitration Act. Also, parties agree to go to arbitration. They arbitrate under the arbitration. The only thing that the Arbitration Act doesn't allow arbitration for is custody of children.
Right.
So you can arbitrate any other dispute, business disputes, family disputes, you know, divorce, separation,
Yes.
you know, how to divide assets
Yes.
between family members or between partners. The only thing that cannot be arbitrated is custody of children,
Yeah, because
the interest of the children
Yes.
and the Children Act, you would know more
Yeah.
than that about me, the Children Act comes into play, and therefore that cannot be arbitrated.
And the theory is that the High Court is the upper guardian of all minor children. So children's rights are determined outside what the parties might not agree to, if there's
right.
no agreement. So you can't override what the judge might hold.
Yeah. And that's purely for the protection. But arbitration as well, like you said about mediation,
Yes.
arbitration is less costly than going to court.
Yes.
You don't have to hire lawyers, parties can do it themselves. There's an advantage to hiring lawyers, obviously, but you don't have to go to court, it doesn't drag out, it usually takes place within 1 or 2 or 3 days, depending on the dispute, of course. It's less costly, we mentioned that.
Yes.
Again, you choose the arbitrator.
Yeah.
You give the arbitrator terms of reference,
Right.
unlike at court, and it remains confidential because court cases gets published, whereas private voluntary arbitration will always remain private unless the parties want it to be public.
Well, not many people might know, but for many years now there's been a very successful initiative by the Muslim lawyers in Johannesburg and the Jamiat in the establishment of the Muslim Mediation Arbitration Commission here in Johannesburg, the council actually. And they've been going on for a very long time, and they've built up quite a reputation in trying to assist people in resolving disputes.
Yep. The Muslim Mediation and Arbitration Council has been running for a few years now. It's advertised occasionally. You hear the advertisement on Radio Islam. I'm not sure whether you have it here on TV. There's a panel of trained, highly skilled mediators and arbitrators. There are people who are skilled in both Sharia law as well as the South African law, so both are covered. And you can also have an arbitration panel where you can have an arbitrator who's highly skilled in South African law,
Yeah.
and an arbitrator who's highly skilled in Sharia law. So, and the Muslim Mediation and Arbitration Council have done a few cases. Not too many people are using it, unfortunately.
Yeah.
It should be propagated more people should use it, but it's been highly successful in resolving disputes through mediation as well.
That's right.
And major, big disputes running
Yeah.
into millions
Yes.
and millions of rands have been resolved, as well as labor disputes. An important thing, Muslim organizations can, in fact, in their employment contract, stipulate that in the event of an employer-employee dispute, they should use the Muslim Mediation and Arbitration Council rather than the CCMA or a bargaining council.
Because as you've pointed out, arbitration can be agreed upon. In terms of the Arbitration Act, you can choose the fora, etc., and you can then take your dispute. Now, you can even choose at the MMAC which law you want to apply. Basically, you can't say, okay, I signed in terms of a civil law, but now I want the Sharia. Of course, if both parties agree that the Sharia would be the basis of which this dispute will be resolved, then you can ask for that
That's
ruling.
important, because, and that's where the terms of reference come in. The parties, because it's voluntary, the parties determine terms of reference. The parties can stipulate, because it's voluntary and because they're going to abide by it, provided, of course, it's not unlawful.
Yes.
You know, they can stipulate that we want our dispute resolved in terms of Sharia law,
Right.
and not the South African law. In other words, the Sharia law must take priority over the South African law.
Yes, within the boundaries, like you just said, there is a proviso, there is a limitation.
Yeah.
You can't, for example, say, I want to carry out the hudud for my, in order to be redressed for the harm, and then you find yourself in the criminal court. We're going for a short break. Please stay tuned, and we'll be joining you just after this break. Assalamu alaikum and welcome back to Legal Ease, the show that converts legal jargon into legal ease. Tonight, my very special guest is Professor Mohammed Raja, and we're discussing alternative dispute resolution and understanding what this is. Now, Professor, we were talking about the various pros and cons of the system. What about litigation? Now, litigation is something that probably everyone knows, and it's made in fact, people are more aware because of the recent high-profile cases that we've seen on TV. What about litigation?
Well, look, there's always the option of litigation. However, that can be a long, drawn-out process. It can be expensive. It can take time, and it is public. Everybody knows about the dispute because it's not private. And it can take a long time. You go to court, and if you lose the case or win the case, one of the parties can then take it on appeal to a higher level, and it can drag out, and it, with the court rolls being as busy as they are, these things can get dragged out for years and years.
Yes.
Whereas, and therefore, arbitration is the easy option because it's quick. It's final. Arbitration is final. There's no appeal beyond arbitration.
Right.
It's final and binding. You can't take an arbitration ruling on appeal. Now, some people may be a bit concerned about that and say, wait, hold it. What if I have an arbitration ruling against me and I know that the arbitrator, for example, was biased, obviously biased, accepted a bribe, did something unlawful? In that case, the arbitrator can be taken on review. So it's not,
so it's basically it's saying that the process was flawed because of the arbitrator's own shortcomings, but that's what you take on review, his own actions.
You take the person on review, not the
merits as such.
Yes, not the award.
Now, I think the legislature has now decided that, look, they have to curtail how matters are coming to court. I mean, it's unnecessary for every matter to land up in court. They've now realized it. So they've put in various ways of trying to curtail lengthy litigation. One of them is the establishment of the small claims court. So where you have disputes of 12,000 rands and less, you, the litigant, without an attorney, without anyone assisting you, you can bring this claim in the small claims court, and you can take any defendant to the small claims court. Irrespective of how big or small he is, and have your claim adjudicated. It's like night court. But the government has now decided on that on the 1st of December, a pilot project will be rolled out, which is court-annexed mediation. Let's talk about court-annexed mediation. So this is dealing with civil matters in the magistrate's court.
Look, Ashraf, we know, I mean, as a lawyer, you probably know, and lawyers out there would know, that you go to court sometimes and you settle on the steps of the court. That happens very often. In
fact, and anecdotally, they said 9/10 of the cases are settled on the steps of the courtroom.
Well, with court-annexed mediation, there's the option of mediation. It's not going to be compulsory, but there are rules that are being put into place that have been approved. It's unfortunately, or maybe fortunately, I'm not sure which, I would have preferred to see it to being compulsory, but it's not compulsory. It's still the experimental stage at this place, and it's used internationally. It's not unique to South Africa.
Yes.
For example, in Britain, if a case goes to court and they are told to mediate, and a party that refuses to mediate, if that party then wins that case, the court will then not award costs in favor of that party against the other party.
So let's just unpack the understanding. Normally, if you win with costs.
Right.
In this case, the Brownlee judgment in the UK said, this case should not have come to trial. It was capable of being mediated. In fact, the legal costs outstripped the actual claim. And I think there the judges were sending out a message saying, no, look, we're not going to entertain this. So you, the counsel that has won in court, you're not going to get your costs because you should not have brought this. Now, that kind of thinking is what colors this new mediation.
That's correct.
proposal.
And because the option was there. So the
Yes.
option is going to be offered here as well. It's going to be at the experimental stage. They, in fact, at the moment, calling for court-based mediators to apply to become mediators, provided they've been adequately trained, provided they have adequate experience. And of course, they're going to have mediators at different levels, senior mediators, junior mediators, depending on the type of the dispute, mediators will be assigned accordingly. But they got, for example, DISAC, which dispute resolution accreditation, trying to establish accreditation standards. So that's going to be in place, and the requirement is going to be for any court-based mediator to be adequately qualified and adequately trained. Because we know at the moment other disputes or voluntary disputes outside of the court-based mediation, outside of the CCMA, parties can volunteer to go to mediation. There are no qualifications required. They can choose anybody to mediate for them.
As you've indicated. Now, in a court-based situation, does the mediator have to have specialized skills? I mean, he can't just be anyone. Surely he has to have some kind of training.
The mediators are going to be highly skilled. They're going to be accredited. They must have the required training.
Yes.
They assist. They cannot purely just attend any mediation training and then expect to be accredited, because there's a testing process, there's an accreditation process. Then only will mediators be allowed to be on the mediator panel for the quarter next mediation.
And just a reminder to our viewers that our lines are open and you can call in on 011 086 7700 1, 2 or 3. I'll repeat the number, 011 086 7700 1, 2 and 3, and the number appears on your screen. Now, Professor, I know you've been through a rigorous training program in terms of being an accredited commercial mediator, and that's with the Center of Effective Dispute Resolution based in London. Now, I mean, that really sets you apart from most of the mediators that I know, because there are certain skills that you require. That kind of training is used in a commercial sense. You could deal with commercial disputes, but surely the same skills you can use in other areas.
Yeah, look, the basic skills are the same. It is sort of mediation skills. It could be used across all disputes, family disputes, for example, divorce disputes, business partnership disputes. It's been used in labor disputes since the early 1980s. We know that's been highly successful, initially with a body like the IMSA, the Mediation Association of South Africa. It was the Independent Mediation of South Africa. Then it became ACAS, and there's AFSA. There's a few bodies.
So it's a highly developed field, and it's now coming to the coming into its let's say its mainstream litigation, which is commercial civil litigation. Before we go on, we have a caller on the line. Caller, please go ahead. Hello?
Hello.
Go ahead, caller. We can hear you.
You can hear?
Yes.
Assalamu alaikum.
Wa alaikum salam.
Brother Ashraf, I must tell you, we're really enjoying the shows, and welcome. Assalamu alaikum to Professor.
Wa alaikum salam.
What I want to know is, according to the Quran, in chapter 4, verse 35, Surah An-Nisa, we read two very important things. I have been practicing a little bit of arbitration, and what I find is, first of all, Allah subhanahu wa ta'ala tells us, وَإِنْ خِفْتُمْ شِقَاقٍ. Shiqaq means anything that can cause any, sourness of relationship. Allah says, فَبَعَثُوا حَكَمًا مِنْ أَهْلِهِ وَحَكَمًا مِنْ أَهْلِهَا. Then you set up an arbitration, but you do not bring the disputed party together immediately. What you do is you work with a representative. And I find that when you bring the two parties together, both of them are emotionally charged, and one would speak something in the attack and defense attitude starts. That is the first point I learned from the Quranic principle on chapter 4, verse 35.
Yes.
And the second thing Allah says, in yurida islahan, a very important thing is that if they both parties desire islah, that is reconciliation, yuwaffiqullahu baynihima. And the most important thing is I find that I have been talking to a lot of people who are trained in this thing about arbitration. And they are told to bring the both parties together, and that's where I find that the things go worse. By bringing the representative and working, and I find that you can get a success. I want some comment on that point of view. Shukran.
Thank you very much, Abdul Samad. Look, I think it's an immense command that you've just read out or explained to us. And it actually speaks to the process, I mean, it's so practical that instead of putting two inflamed parties together, keep them aside, get somebody else to talk on their behalf that doesn't have the emotion, and let's deal with the facts. I mean, that is such an incredibly practical thing to start off with.
Look, Brother Samad obviously raises something very, very valuable, but we need to make that distinction because I think sometimes the word arbitration mediation is used too loosely.
Yes.
Because in arbitration you have to have the parties together because they lead evidence, there's questioning, there's cross-questioning.
Yes.
I know we sometimes loosely talk of mediation when, I mean, people say arbitration when in fact they mean mediation.
Yes.
And in mediation, the mediator who's highly skilled will determine whether to keep the parties together or separate the parties. As a start, often in terms of the process, the parties would be together, but then the mediator will separate the parties and talk to them in separate rooms perhaps, going from the one party to the other party, for exactly what the Brother Abdul Samad said. If you bring them together, they're going to be fighting with one another. So therefore, as mediators, we keep them apart till an agreement is reached. It's only when the agreement is reached, the agreement is put in writing, the parties sign, then the parties may be brought together. But even in that case, sometimes, even then, parties aren't brought together and kept apart.
So it all depends on the circumstances of a particular...
It depends on the dispute, it
Yes.
depends on the parties,
Right.
it depends on their relationship.
Yes. So we were talking about the skills of the mediator. So he's a highly skilled, trained mediator. I mean, it's a training process. This is not something that you can just take the seat and hope to get the parties to work towards a solution. That's the magic, is that the mediator's role is to encourage the parties to find the solutions for themselves.
That's true. But also an important role of the mediator is to uncover what the true interests are of the parties.
Right.
You see, because often parties put on the table what their dispute is.
Yes.
And they say this is what they want. That's their position.
Yes.
But the mediator will then uncover what the parties' interests are, because parties may have underlying interests. It's like the proverbial iceberg.
Yes.
What you see above the water
Yeah.
is just the tip of the iceberg. What is below the water is really
the problem.
The dispute is about.
It's the ice that sunk the boat, basically.
If I may, Ashraf, the example we often use.
Yes.
There's an orange on the table, two kids run and they grab the orange and they both fight over the orange and says mine, orange and mine. And the adult walks in and the adult then takes the orange, cuts it in half and gives each of the kids half an orange.
Yes.
When in fact what the adult has done has given them half of what they wanted.
Yes.
Now,
yes.
if the adult was a skilled mediator, the adult would have asked, why do you want the orange? And it may be that one of the parties wanted the peel because they've got a school project to bake a cake.
Right.
And the other party wanted the orange to eat or the juice
So
of the
establish the reasons,
orange. Establish the underlying interest.
Right.
And that's what a skilled mediator does in a dispute.
We have another caller on the line, Professor. Please go ahead, caller.
Yeah, you're speaking to Tabelo, calling from Kuruman.
Welcome,
Tabelo.
I just want to ask, can mediation be done through telephonically?
Mediation, can it be done telephonically, Professor?
Yeah.
Yes, it can be done telephonically.
Okay,
Often it does. And these days, because of the internet, you've also got things like, I presume the brother's still listening. These days with the internet, you can also do it through Skype and other media. You can do it, even internet, there's a sort of internet-based mediation as well, which is huge internationally, even for businesses. So yes, even on the telephone. In fact, the CCMA commissioners sometimes, when one party pitches at the conciliation or at the mediation, and the other party is not there, they would mediate over the telephone. So the answer is yes, you can mediate over the telephone.
So that's quite refreshing. I mean, you could use technology like Skype. I mean, you're still having the person there face to face, you're listening to him, he's able to put forth what he really wants. And like you say, it's an attempt to try and drill down to what the real issue is here. It's not all the other peripheries, but what the real issue is.
In fact, you don't even have to meet the parties on the same day or at the same time.
Okay.
You know, you can meet one party on one day and meet the other party another time, another day, because sometimes the parties themselves cannot come at a particular time and they have separate days or different days at which they can meet the mediator. So that's an option as well. Ideally, of course, is to have the parties together at the same time, not necessarily together in the same room, but together with the mediator. The mediator will then keep them separate in separate rooms and deal with them and do shuttle mediation, go from the one to the other party.
And on that point, we need to take a short break, and please join us after this break. Assalamu alaikum and welcome back to the last segment of Legal Ease, the show that converts legal jargon into legal ease. And tonight my very special guest is Professor Mohammed Raja, and we're talking about alternative dispute resolution and what do we understand by that. Professor, we were talking about the skills required of a mediator within the civil cases that the courts are now trying to establish. Those have to be skilled and trained.
Yes, they have to be skilled, they have to be accredited.
Right.
They have to have acquired the training, and of course there's some experience needed.
Needed, yes.
Yeah.
Now, assume I'm not an attorney or legal person. Can I be trained as a mediator?
I'm glad you asked that, because often people think it's confined to lawyers. A lot of mediators, in fact, perhaps the majority of mediators are not lawyers. We often, when we're busy with training, we say sometimes that the non-lawyers make better mediators than the lawyers, because some of the lawyers focus on what their clients' rights are, and rather than what their interests are. And they say, if we go to court, we can win this case, whereas the mediator looks beyond that and looks at the interests of the parties, looks at the relationship of the parties, because often it's an ongoing relationship.
Yes.
It doesn't end at the mediation, whereas going to court, that often brings the relationship to an end.
To an end, because someone is going to be bitter
because
at the
you're
end
going to
of
have
that
a winner
process.
and a loser.
That's right. So I think what you're saying is, in mediation, you actually have a win-win situation. You're trying to salvage what is important between the parties, and is there a way to try and quieten the difficulty so that the relationship can persist?
Yeah. And of course, you also show the parties really, what they've been fighting over may not really be worth the costs that are going to be involved if they go to court. You help them see the issue more clearly,
right,
by using the skills that are gained through the mediation training.
Now, mediation, you mentioned earlier on, is used in the international arena as well. In fact, today I was doing some research and I was astonished to find that there is an organization in France that only deals with trademark mediation, and they have some German lawyers as well. So these are international trademark disputes that have gone to mediation, where there's market share and there's disputes regarding. So normally they would end up in court, but in this case they've decided to mediate. So What can you tell us about international mediation?
Well, you mentioned Paris because the International Chamber of Commerce, for example, in Paris, they, and people can Google that and get the information if they want, because we're not going to have time for the details.
Right.
They run mediation and arbitration. They offer mediation and arbitration for international disputes between companies, international, multinational companies. It's mostly commercial disputes, not family-based disputes. February every year, they in fact run an international mediation competition,
Right.
where they have law students, business school students, students doing negotiation and conflict management from all over the world.